I'm going to rate this new lawsuit that was filed by another lawyer. As a wage and hour lawyer, I'm always curious about what other lawyers are doing with their wage and hour cases. So as you can see from this complaint here in federal court, it's filed in Newport News Division in East Virginia. And I kind of like the format up here on it's kind of different in that it has a dark line separation. So format wise, it's very clean. I do like the spacing on it, and the font's probably promulgated or dictated by the local rules. But let's take a look at the introduction. There's a section right here. It talks about the three statutes that's involved in this lawsuit. One is the Fair Labor Standards Act, which covers overtime and minimum wage. The next one is the Virginia Minimum Wage Act, which is the state equivalent of the FLSA that requires employees to be paid the minimum wage. And the third statute right here is the Virginia Wage Payment Act. A lot of states have a statute in place that says you got to pay your employees. You just can't cheat them on wages. And this is a quick description right away. This lawyer drafted it, and he describes it as the employer as a business that provides outpatient health services to patients. And the plaintiff worked as a medical billing specialist. I like this quick intro. They jump right to the facts of the case and explains the context on why this lawsuit is being filed, because they start off with a bunch of statutes and then they provide the facts right away. I like that quick punch. And you can start thinking as a reader why this plaintiff is involved in a lawsuit that requires minimum wage. And then right away, it says that the plaintiffs contend that the defendant violated her rights under the three statutes, and she seeks minimum wage, liquidated damages, pre and post judgment interest right here, and attorney's fees and costs. So right away, you introduce the statute, the facts of the case, what the plaintiff is seeking, and it's pretty good. I like the way that they drafted it so far. The next section is the jurisdiction section. This is pretty important because you have to explain to the federal court why the judge has jurisdiction. And so right away, they mention the FLSA, which is a federal statute, and so it belongs in federal court. The court has jurisdiction over all claims filed under a federal statute. And then, interestingly enough, there's a little introduction that says that the federal court also has supplemental jurisdiction over the state claim laws, and there's a statute that provides that. And so that if you have the same facts, but it covers two different laws, one federal, one state, this section of the federal statute allows the federal judge to have supplemental jurisdiction over the state statute. And there's a mention that why is it filed in federal court in Virginia? Well, paragraph 9 states that the defendant is in Virginia. All right, let's talk about the next section. The factual allegation section is clearly labeled. I like this in that it states immediately what the arrangement is and how the plaintiff came about to work for this employer. And it basically states that she applied for employment for a remote job according to a job posting, and it states the hourly rate, and this job allows her to work remotely from her home office in Virginia. So right away you have established that the employee worked for this employer. You really didn't have to add additional facts about how she found the job, but it's kind of good anyways. It doesn't hurt to add it in there. But the important part is that it talks about this is a remote position, and she worked in Virginia. Now, the important thing is that she mentions that she did not get paid for 2 months of work, and she resigned due to the defendant's failure to pay. So this is important because this is the basis for the lawsuit itself. It states right here that she resigned because she didn't get paid for 2 months of pay. That's pretty bad to allow someone to work for you for 2 months and not get paid. So as a result, they're suing for minimum wage violation and under the federal and state equivalent. And the third is the wage claim, because Virginia has a statute that says you got to pay our workers. You just can't get work for free. There's an interesting section below. It states that it's a willful violation, meaning you get liquidated damages because as an employer, I'm pretty sure it's easy to establish that you need to pay workers, especially if they worked for you for 2 months. You need to pay them. And so you can't say, I didn't know there was a law that requires me to pay workers. I like how the lawyer structured count 1, violation of Fair Labor Standards Act. That's pretty good. Count number 2, it states the Minimum Wage Act required under the Virginia statute. And I do like that they repeat all the facts again. Personally, I don't think it's necessary to mention all those facts because you already mentioned it above in the facts section, but it doesn't hurt to repeat those facts to get the employer to admit certain things. And count 3, again, they're restating all the facts for the establishment of the violation of the minimum of the Wage Pay Act, the Virginia Wage Payment Act. It's optional. I don't think it's necessary to mention all the facts, but it's good that they do it anyways. It's more like a stylistic approach. Under the prayer section, the lawsuit has to mention what they're suing for, and I do like the fact that the attorney separated the prayer section into 2 sections: relief under the federal statute and then relief under the Virginia state statute. And so it's kind of confusing sometimes when you have the same type of remedies available under 2 different statutes, and the attorney basically did not leave anything up for imagination. They just repeated the same language available under the remedies available under the federal statute, the FLSA, and then the remedies available under the Virginia statute. And the reason why this is important is because you actually have to state in your lawsuit what remedies you're seeking and under what statute is permitted. And sometimes the way the state statute is written, it's a little different from the federal, so you can't assume that the judge or the opposing attorney understands that's what you're seeking. And to put the other side on notice, you do need to write all of these things down separately. I think it's the best approach. So I would give this lawyer a 10 out of 10.